If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. As a business owner, contracts are probably the most common way that your business interacts with the law. And we are constantly signing contracts, asking other people to sign contracts. And yet it's something that a lot of business owners either don't fully understand, or there's a lot of misconceptions and myths about contracts and how they actually work. And so today we are going to be talking about contracts, because as business owners, again, we're constantly signing contracts, asking our customers or our clients or our employees or our contractors to sign contracts. They're such a part of our business, and that's why it's so important for business owners to really understand what's going on in the background. What are some things that would be helpful to know as a business owner that could help you be more effective as you're going about this area of your business and as your business is interacting with just kind of the legal side and business law in general. So if you are new here, welcome. My name is Christian Hammond. I am a licensed attorney here in the US. And so we are going to be most focusing on US law. And I specialize in helping small businesses and entrepreneurs get legally protected so they can grow sustainable, profitable businesses. So thank you guys so much for being here. I invite you to grab a notebook and take notes, because this is going to be really helpful, really actionable for you as a business owner, really regardless of what business you are in, because regardless of what your business is, you are going to be dealing with contracts. So grab a notebook, grab a pen, grab your iPad, your stylus, whatever you want to take notes on, and let's get into it. So today I really want to break open the black box of what's really going on with business contracts. And specifically, I want to give you guys 3 things that would be really, I think, would change the game for you as a business owner, to know, to be aware of, and just to have more context for how these things are really operating in the background and kind of the legal perspective of what's going on. And so for many of, probably for every business owner here, contracts are the most common way that your business is going to interact with the law just on a daily basis. If you have a brick and mortar store, well, then your landlord at some point is going to send you a commercial lease. That's a contract. You probably have contracts if you are selling products with your distributors, with your manufacturers, with your vendors. If you have a service-based business, then you have contracts with maybe your subcontractors or with other employees who might be working for you. You have contracts with your clients. And then, regardless of what type of business you have, whether it's product or services, there's all kinds of third parties who, at any given time, are either asking you to sign their contract, or just the fact that you are even using their service means you've already agreed to their contract. Services like Fiverr, services like Upwork, even every time you Google something or ask ChatGPT a question, these are all subject to what's called a terms of service. All these different services have terms of services. And whether you realize it or not, as a business owner, you are agreeing to those contracts just by using the services of Fiverr, Upwork, whoever it is. So contracts are everywhere in our business life. And in fact, they're also everywhere in our personal life. Again, pretty much any kind of online platform you can think of. If you play video games online, those video game companies have a terms of service that probably just by playing the video game, you've already agreed to. Every time you post on social media, in fact, every time you scroll on social media, you are agreeing to the terms of service for that social media platform, whether it's TikTok or Instagram or YouTube or X, whatever it is. Again, even when you're not online, if you have ever purchased a product, even really simple, relatively simple products like a toaster or a blender or a pair of earphones, a lot of times you'll get this small folded up piece of paper that comes in the box that has some legal terms on it. Again, even for something simple like a $20 toaster from Target is probably going to have a small little folded up piece of paper with some legal terms on it. And so, why is this? Why is it that every time you go online, or even if you're buying a $20 toaster from Target, it comes with some form of a contract? Well, it's because those businesses understand that contracts are crucial to their business. And as you start to become as your business starts to become more of a company, as your business starts to become more of an organization, as you seek to really buckle down, get serious, get your ducks in a row, and really start running your business as an enterprise, then it's going to be time for you to also get more serious about your contracts. And I want to pause here because I think that for so many business owners, anything legally related can engender some amount of anxiety. And I want to pause right here because, of course, contracts are a legal document. So I think for many business owners, just the fact that contracts are tied to the legal side of their business can generate some level, maybe a lot, maybe a little, but some level of anxiety. And I want to totally reframe how we as business owners think about contracts. And I'm going to give you two options, and you can choose whichever option works best for you, your personality, and how you like to think about things. I'm going to give you two options for how to re-envision your relationship with contracts. A well-written contract is like a warm, fuzzy blanket. Like so cozy, just makes you feel safe, makes you feel secure, makes you just feel warm and cozy. Or, for some people who are my warm, fuzzy blanket people, that image works great for you. Now, if that doesn't work for you, I have another option. A well-written contract for your business as a business owner is like a super ripped bodyguard who works for you or a security guard who works for you, because they have got your back. They are protecting you. If something goes down, they are going to take care of it. So I don't know which image works better for you. If you are more of a warm, fluffy blanket person, or if you are more of a ripped, swole security guard, bodyguard person. But regardless of which image you prefer, a well-written contract should not be something that gives you anxiety. As a business owner, it should be something that gives you comfort. This is something that has your back. This is something that makes your business run more smoothly. This is something that when something goes wrong with a customer order or something goes wrong with a client project and you have that kind of temporary moment of anxiety, that's when you remember, oh, wait, I have a really well written, thorough, strong contract for my business that is already signed and in my back pocket. And I have that extra layer of assurance that even if this, that, and the third went wrong, I can fall back on my contract. It's that warm, fluffy blanket. It's that super ripped bodyguard. So I just wanted to stop there and reframe how we're even thinking about contracts. Just because it's something legal related doesn't mean it should give us anxiety. In fact, it should give even more confidence. So now that we've reframed how we're going to think about contracts, I want to jump into the three things that I think many business owners don't know or are not aware of when it comes to contracts, but that I think could, again, really be a game changer and would really be helpful to know as a business owner. So the first thing that I think a lot of business owners don't realize is that the core agreement for your business, the master agreement for your business that either all of your customers are automatically accepting just by being on your website and buying your products, or if you are a service-based business, your master services agreement or your professional services agreement, whatever that core agreement is that all of your customers or all of your clients are signing, it probably needs to be longer than you think it needs to be. Most of the time, when clients come to me to create a core or a master agreement for their business, a lot of times they'll say, oh, my business is pretty simple. So I don't think, I need a long contract, maybe 3 or 4 pages or something like that. And I want to here define the difference between a business being common, meaning it's an industry a lot of people are in or it's a job a lot of people have, versus the business being simple. Your business might be common. Maybe you're a hairstylist. That's a common profession, right? A lot of people are hairstylists. A lot of people are in that industry. Yes, it's very common, but that does not mean it's simple. Or maybe you're a photographer. A lot of people are photographers. Yes, it's very common, but that does not mean it's simple. Because if you really think about it, there are materials, there is supplies, there are logistics, there are conditions, there are requirements that need to be in place for you to create the best possible product, for you to do the best possible job, for your client to have the best possible experience. There's requirements, there's supplies, there's materials, there are things that need to be in place. And so when you really get down to it, you might realize, oh, okay, yes, my business is common, but it's not necessarily simple. And just to roll with that photographer example, if you're a photographer and you're showing up to a site to complete some kind of a shoot, there's all kinds of prerequisites that need to be in place. You need to know where it is. You need to know what time. You need to have worked out, are they flying you out, or are they paying for your travel, or are you paying for that travel? If it's going to be a full day, are they providing the food, or are you bringing your own food? Are they providing the makeup artist, or are you bringing the makeup artist? There are so many details that go into how this thing actually works. And so when I get into it with clients, and I'll just say that usually when I'm creating that first custom contract for a client, that client that believes that they have the simple business, even for the most simple business, that contract usually ends up being at least, I would say, at a minimum, it usually ends up being about 7 pages. And sometimes that's surprising to them. But when we get into that contract and we're going through things, I have never had a client then turn to me and say, oh, this feels like too much. It's always the opposite. As we're going through things, as we're going through all the things that have been included in the details, they're always like, oh yeah, I'm so glad you included this. Or, Ooh, that happened to me once. I'm so glad you thought of that. Or, ooh, that happened to a friend of mine. I'm so glad that this is in here to protect me. I have never had a client say, ooh, this feels like too much. It's always been the opposite. They're always like, oh, yeah, this feels really good. Oh, wow, I didn't even realize I needed this. Oh, wow, this makes me feel so much more protected. And that is the difference between your business being common, meaning a lot of people are in that industry, versus it being simple. To give you another example, let's say you're in the events industry. And many different people could be in events. Maybe you're an event planner, again, photographers, but also makeup artists. Maybe you are in transportation. Maybe you have a luxury travel company. There's so many different types of event careers. But let's say that you are an events professional. And let's say that you are in this place where you're like, well, my business is pretty simple. You might be thinking, to pull off this event, all I really need in my contract is what day, what time, where, and when are you paying me? You might think, oh, it's pretty simple. That's all I really need to know. Well, here are a few things you might not have thought of if, for example, and this is just one example, you're in the events industry. Allergies maybe is something you might not have thought of. If you are a makeup artist, a lot of people are allergic to makeup. What happens if you're working on that bride and she breaks out into hives? What is the plan at that point? Same thing as a hairstylist. Certain people are allergic to different hair products. What happens if you're done with the style, you get to the end, you go to add the hairspray, that person is allergic to hairspray or that specific type of hairspray that you're using. And maybe it's an allergy they knew about, but they didn't, they just didn't think to let you know about it. Now you've already done all the work, you're at the end, but you can't use that product and you need to rinse it all out and start over. A best case scenario. Worst case scenario is now you're calling, support or medical support for that person. So, God forbid, but best case scenario is starting over. Worst case scenario is something much worse. If you're in the food industry, same thing. Now, if you're in the food industry, you're probably well aware of food allergies and dietary restrictions, and you probably have things in place to handle that. But what happens if there's a mistake? What happens if one of the guests was allergic to peanuts and a member of your team got the number placements mixed up and gave them the wrong plate? What happens at that point? What is the plan at that point? Who is responsible at that point? That is what a thorough and good contract answers. Another thing that people often don't think of is something like access. Again, if it's events, do you have access to the venue? Is there a place for you to park without getting towed and without getting a ticket? Raise your hand if you're in the events industry and you've ever gotten a parking ticket for parking at the event you were working at, right? These are the kinds of logistics that need to be worked out. And the last thing I would say is, just another example of things people don't always think about is security. I don't have to tell anybody in this day and age that people are crazy, right? And so, especially if you are an events professional, having that clear out in the contract in case you need to exit stage right from a situation, either because of the client themselves, perhaps engaging in behavior that's not appropriate, or that's just not appropriate. Having that clear out in the contract is so important. And unfortunately, I have had clients come to me after an incident realizing, hey, I need a change to my contract because this happened that was not okay. And I need to clear out in my contract if this situation was to ever happen again. Super important to have those kinds of things. Even as an attorney, I have those kinds of things in my own contract because it's just so important. And so these are just a few examples. But even as I'm talking, I just gave the example of being in the events industry. But regardless of what type of business you have, you're probably starting to think like, oh yeah, like I might be in a very common type of business, but that does not mean it's simple. There actually are a lot of details. There actually are a lot of things that go into what I do. And you might not be conscious of that on a day-to-day basis because it's all in your head. You've been doing this for a long time. You've been doing this for many years. On some level, maybe you could even do it with your eyes closed. But if you've ever had to take the processes that are in your head and try to write them down for somebody else, maybe an employee, for example, you've probably realized even at that point, oh, wait, this isn't as simple as I thought. It's, second nature to me, but that doesn't mean that it's simple. And I just want to close out this point by saying that even though I'm saying that, hey, that master agreement for the business often is longer than a business owner needs to be longer than a business owner realizes it needs to be. I also want to be clear that I am not advocating, you know, overly long contracts just for the sake of being long-winded. So, there are pitfalls to contracts that are too short, too bare bones, too basic, just don't have enough information. There are plenty of pitfalls to that, and we just talked about a few of them. But there are also pitfalls to contracts that are overly long, overly complicated for no reason. Because when a contract is overly long, a lot of times it has overly wordy, unclear language in it. And when it comes to the legal world, being ambiguous is just as bad, if not sometimes worse, than not saying anything at all. So I'm not advocating length just for the sake of length or wordiness just for the sake of wordiness, because having a contract that is sloppy, messy, and ambiguous and overly long can be just as bad, if not worse, than having a bare bones, overly simple, overly basic contract. So both of those have their own pitfalls. And sometimes having a short contract, or you can have incredibly short yet still incredibly effective contracts. And I think the perfect example of this is Borat. Now, I'm not endorsing the Borat film. I am not advocating for a style of filmmaking where people don't realize what they're actually being filmed for. I'm not co-signing that. All I am saying though is that the contract that was used for Borat is in many ways a masterclass for how to have a very, very short but very, very effective contract, because there have been tons of lawsuits following Borat, many of them from people who were in the film who did not realize they were going to be in the film. And the Borat contract is kind of famously under a page, very short but yet very effective. And that contract has stood up against lawsuit after lawsuit after lawsuit after lawsuit. So longer isn't necessarily better, and you don't have to be longer to be effective. But I have found that for most small business owners, they usually need more detail than they realize that they need. Moving on to the second point that most business owners don't know about contracts, but it is helpful to know about contracts, is that when someone else is giving you a contract, your landlord is asking you to sign a commercial lease for your retail space, or your distributor is asking you to sign a contract, your manufacturer, your vendor, your accountant, your bookkeeper, whoever it is. When someone else is giving you a contract, one thing to realize is that that contract, more often than not, is not customized to what you guys are doing. It's not customized to you. It's not customized to your transaction. That's just the contract that they send to everybody. Everybody gets the same thing, and that's just what they send to everybody. And I say this because many times clients will come to me to look over a contract and they'll be confused because they're like, hey, again, my distributor, my manufacturer, my vendor, my accountant, my graphic designer, whoever it is, they send over this contract and it's just, it has sections that don't make any sense. It has sections that don't apply to me. This doesn't seem right. It has sections that are different from what we talked about. And there can be just this confusion of like, why would they put in all these sections in the contract that don't apply to me and don't seem to make any sense? It's because that's the same contract they send to everybody. And so I think that really brings a lot of clarity, because this contract usually Maybe they change the names, maybe they update the dates, maybe they change the dollar amounts. But other than that, it's not like their legal team sat down, went through the contract with a fine tooth comb, and then customized it to you. More often than not, that is the same contract that they send to everybody, which means that it's on you. It's on you. It's on you to read it. It's on you to suggest changes. It's on you to identify the things that don't really make any sense and don't actually apply to the transaction you're trying to do. They're putting all of that on you because, why would they spend their time doing it? They already have a template that more or less works for them. So they're giving it to you saying, sign this. And that means, hey, if you have a problem, let us know, but otherwise sign this. They're putting all of that on you. And I think that brings a lot of clarity because so often clients are kind of like, why does this contract kind of have nothing, or why are there sections in this contract that kind of have nothing to do with the deal we're trying to do? It's because that's the same contract that everybody gets. And it's on you to make suggestions, revisions, and ask for changes to customize it more to what you're doing. And ideally, at that point, that is when you bring in a lawyer to handle that for you. And I think that that's also really important to understand because when you understand that you're just looking at a template and it's kind of being put on you to make any necessary adjustments, uh, what is also true in my experience is that reasonable people will accept reasonable changes. Reasonable people are happy to make changes that make sense, to make changes that would customize it more to the deal, customize it more to the transaction, customize it more to your business, etc. Now, once in a while, you will deal with someone whose response to your reasonable requests or your attorney's reasonable request for changes is, oh, we can't do that. We don't change our contracts. All of our contracts are the same, and everyone signs the same thing. Now, you might interpret that as a business owner as, oh, they're not willing to negotiate with me. But in my experience, that response usually means one of four things, and it might not be what you think it means. A response that says, we can't change anything, this is set in stone, you have to sign it as is, no ifs, ands, or buts. It usually means one of four things. One, it means the person you're talking to does not have authority to make changes. It means that the person you are talking to would have to go to their supervisor, would have to go to their manager, would have to go to somebody else to get approval, and they don't want to. Sometimes that's what's going on. You are talking to someone who does not have the authority to make changes, and they don't really want to go to their supervisor and ask for it. So that's one possibility. Another possibility is that you're dealing with a company that does not have a lawyer. And so they're not comfortable or they're uncomfortable with the idea of making changes because they don't really have a lawyer to look over those changes. Sometimes, companies had one lawyer one time draft that kind of standard agreement they send to everyone, and they haven't talked to that lawyer since, or that lawyer doesn't work there anymore. So they themselves lack the confidence to edit a legal agreement, and that's really why they're pushing back. Another option is, when they say, no, I'm not going to, no, we can't change anything. What that really means is, to change this, I would have to go talk to our legal team, and I don't want to do that. Could be because the legal team doesn't like them. Could be because they don't like the legal team. Could just be because they don't want to take the time. But sometimes a no actually means, I don't really want to have to go talk to my legal team about this. And then lastly, the fourth situation that can be at play when someone just flat out says no to negotiating the contract, I would say is in a situation where it's a release. So a movie film is a film is a perfect example. A release in a situation like that, they want to be able to eventually sell the film to a studio, or they want to be able to eventually monetize their podcast, or whatever kind of media it might be. they want to eventually probably sell that to somebody else, a producer, a studio, whatever it is. And when that happens, they don't want to have to go back through the releases and say, oh, so and so gave us the rights to their name, but so and so only gave us the rights to their voice, and so only gave us the right to use this many scenes. They don't want to have to do that. And so the reason they want everyone to sign the same release is so that when they go to sell that movie, that film, or whatever to whatever studio, they have the confidence that everyone signed the same release. Now, that doesn't mean it's a no. That doesn't mean you can't still negotiate the release. I'm just giving you these four examples so that you can have more understanding about what's going on in the background, so that you can have more context for what might really be happening when someone gives a hard no, and so that you can understand what the pain points might be. Because when you understand what those pain points are, that empowers you to be a better negotiator. Because you can't, I'm not going to say you can't, but it helps to negotiate when you know what the other person's pain points are. It helps to negotiate when you understand the limitations that the other party is maybe dealing with. I just think that that empowers you to be a better negotiator at the end of the day. All right, so that was the second one. So the third and last thing that I think a lot of business owners don't know about contracts, but is good or would be helpful to know about contracts, is that contracts, generally speaking, they're not written in a neutral manner. It's kind of there's three options for how a contract might be written. It might be written in the other person's favor. It might be written in your favor, or rarely, it might be written in a balanced way, in a way that's meant to account more or less, for the interests of both parties. And I think that that context is really important when you're approaching a contract to understand, hey, is this a one-sided contract? Is it in their favor? Is it in my favor? Or is it one of those rare balanced contracts that's kind of written with both parties in mind? And I think that context is important, because when you get a contract from whoever it is, maybe it's a client that you're going to be working for, maybe it's a distributor, a manufacturer, whatever kind of contract it might be, your accountant, a bookkeeper, whoever it is, when you get that contract and you do get that very, very one-sided contract, your gut reaction might be, oh, wow, this person's a jerk. And maybe they are. They might be. But what can also be true, again, going back to what I said before, sometimes a business had one lawyer draft one contract a long time ago, and that's what they've been using ever since. And in that situation, a lawyer is more likely to draft a one-sided contract, because that makes it less likely that it's going to come back to bite that person you're dealing with, to bite them, and to come back to bite them, which means it's less likely that they come back to the lawyer unhappy about the work. That's just like part of the reality of the dynamic that's going on in the background. So when you get that really one-sided contract, again, I think it's so empowering to recognize this is probably the same thing they send to everybody, which means, once again, it's on you. They're putting it on you. It's your responsibility. And ideally, hopefully, you have a lawyer who can do this for you. It's your responsibility to go in there, to make it make more sense, to customize it, to make the suggestions that it makes sense to make. And I think that it's also helpful to understand that from the other side. When you're sending someone a contract, that is a representation of your brand. Yes, contracts are also part of your brand. And I actually think that a lot of large companies are starting to understand this, and you're starting to see differences in how large companies draft their contracts. But I think that as small business owners, we need to get with this too, and understand that that contract you are sending to someone, hey, that's part of your brand. That is part of the experience they are having with your business. That is part of the impression that you are making on someone. And when I go to hire someone, I'm hiring an accountant, I'm hiring a bookkeeper, I'm hiring a social media manager, whoever I'm hiring. When I meet with them and I have that initial excitement to work with them, but then they send over a whack contract, it's sloppy, it's messy, it's whatever, that affects my enthusiasm as a potential customer. That it affects my enthusiasm as a potential client when initially I was excited to work with you, but now you sent over this whack contract and I'm kind of like, oh, maybe you're not actually serious about your business. Maybe you don't actually know what you're doing. It undermines my confidence. And that's not what we want. Your contract is an extension of your brand, and it should be a tool that is giving your clients, your customers, your partners, your whoever, it should be giving them more confidence in you, not less confidence. It should be making them more excited to work with you, not filling them with more doubt. Does that make sense? I hope it does. Um, so that is all I have for you guys today. I hope that this was helpful to just really peel back what's going on, to really kind of look into the black box, to maybe dispel some myths, maybe to bring some clarity to a contract you are confronting in your own business as a business owner. And as always, these are things, hopefully, that you are not actually directly doing because there are better uses of your time as the CEO. And if you are looking for that right law firm, you're looking for that right law firm to partner with to take that off of your plate, to free up your time as the business owner, feel free to reach out. You can check out the show notes, schedule a discovery call. I would love to chat with you and love to meet with you. All right. Have a great day, guys. Thanks for tuning in. Bye. Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.